right. Ma'am, can you tell me what case you're joining in on?
I'm sorry, what?
Can you tell me what case you're calling in on?
Yes. It is Catherine Ann Richter and Diana Bonnie Harlakevich versus Dominic James Borowiak and State Farm Mutual Automobile Insurance.
Okay, and can you tell me your name, please?
I am Catherine Ann Richter.
Okay, all right, very good, thank you. Okay, it looks like we've got the attorneys connected. Maybe. There we go. All right, so we'll go on the record now. This is Richter versus Borowiak. This is file number 24-19878. If I could have both counsel put your appearances on, starting with plaintiff, please.
I'm not sure if Gary is here for Richter or not, Your Honor.
No, I'm not, Your Honor. I have a different case. I'm here
Mr.
for
Hands, what?
Matthew Koss is counsel for the plaintiffs.
Okay. Mr. Hands, what file are you calling in on?
It's case number 25-20054. MidFirst Bank.
Oh, okay, gotcha. Okay, I'm just going to place you on hold for a minute then,
Sure,
okay?
sure.
And I do see Mr. Koss is joining in now. Okay, Mr. Koss, are you able to hear me okay?
I can hear you fine. Good afternoon, Your Honor. How are you?
Okay, good, thank you. Okay, so we're on the record in Richter versus Borowiak. We have Mr. Koss now present on behalf of plaintiff. We have Mr. Miller here on behalf of defendant State Farm. Mr. Miller, is Mr. Benzinger or somebody from his firm still in this case, to your knowledge?
I do not know the question of that. We mediated the case recently. There was a mediator's proposal. I'm not sure what happened with the third party component. Matt?
This is a good question. I just reached out to the mediator. I haven't seen anything relative to that. I'm wondering if maybe I missed that email and maybe that's why the third party defendant isn't here, because that part settled. I know, Judge, the very modest small PIP claim that we have with Mr. Mueller here is still outstanding on behalf of Ms. Richter. I had been waiting on 2 bills, which I got this morning. We've been trying for 2 months, and I finally got them this morning. So I think that eventually the PIP portion of the claim is going to get wrapped up pretty easily.
All right.
Judge Mike, I see I have at least one client here. Are you going to need my clients today to stay on? Okay.
No, I mean, they're of course welcome to stay on, but I don't think we'll have them participating in this part of the hearing. This is set for a status conference today. So I guess, Mr. Koss, in light of what you said, I was going to use this date to determine, what future dates we needed to set, or how you wanted to go forward based on the current status. So, Mr. Koss, can you kind of address that for me?
Judge, I would propose a 30-day adjournment of this hearing, and I think that we don't come back.
Okay. Mr. Mueller?
I don't have any objection, Your Honor. With the holidays and whatnot, we may want to go a little bit further just to be safe.
No problem with that, Your Honor.
Okay, so I guess what I'll do is I'll set this for a kind of a control date status conference in 60 days. If the parties are able to resolve it prior to then and we get closing documents, we'll take that date down and won't have to appear. If not, then that gives us a next date to touch base Mr. Koss, is there anything else that I can do for your side here today?
Oh, I appreciate the court's understanding of where we're at. I mean, we have been diligently working to resolve here, and I think that now that I've finally gotten what I've been trying to get for months, we should be able to pretty easily. And whenever the court wants us to come back, I'm fine with that. And I'll just ask if, for the next status conference, if the clients, their presence is needed or not.
Okay. Okay, Mr. Mueller, anything further from your side?
No, Your Honor, I appreciate it.
Okay, thank you. That's all for today. The court will send out notice of the date and time of that next hearing, and all parties are free to disconnect on this file.
Very
Thank
good.
you, Judge.
Catherine, I'll give
Thanks,
you a
Matt.
call later.
I'll wait to hear from you, Matt.
Very
Thank-
shortly, Mark, very
Thanks.
shortly. And then Catherine, you can hang up and I'll call you.
Still have that mid-state
Yes.
whatever on the docket, because that's not on the schedule.
Oh. Yeah, I've got it. I think it was added late,
No.
so that might be why.
Okay.
Then there is an order clipped on the
Oh,
front.
this is a motion for stay, okay. Okay, Mr. Hands will go on the record in MidFirst Bank versus Karanka. This is file number 2520054. The record should reflect that Mr. Hands is present today on behalf of plaintiff. This was set for 1:30. No other parties have appeared. This is your motion for a administrative stay. Mr. Hands, I did review your brief and the motion. I do think it's appropriate. I note that you did submit a proposed order. Is there anything that you wanted to state for the record in support of your motion?
No, Your Honor, I appreciate you reviewing my motion. It's pretty straightforward. We just need some additional time and hopefully this borrower can get back on track.
Okay. All right. So for the reasons stated in plaintiff's motion, I do find that administrative stay is appropriate. As I indicated, I've signed that order. Mr. Hands, anything else I can address for your side today?
That's all I need today, Your Honor. Thank you.
Okay, thank you, and you're free to disconnect.
Thank you.
Ma'am, on the Fire tablet device, can you unmute and tell me your name, please? You're still muted.
Vera Collins.
There we go. Ms. Collins? Okay, great. Thank you.
Afternoon.
All right, hello. There's Mr. Collins. Okay, looks like we have everybody connected. So we'll go on the record now in Collins versus Collins. This is file number, whoever's talking, can you please not talk?
I can't see.
No.
Where's your phone?
Shelley, I gotta have you guys be quiet. Judge is calling the case, okay?
I'm
My
trying to
client's
mute you
daughters
guys.
are helping him. I'm sorry.
Yeah. Mr. Collins, on your end, can you just remain muted for now, please? There's background noise that's causing a problem. There we go. Okay. As I was saying, we're going to go on the record in Collins versus Collins. This is file number 25-20024. If I could have both the lawyers put your appearances on, please.
Thank you. May it please the court, Chris Rickard appearing on behalf of the plaintiff Clarence Collins, who's also appearing via Zoom.
Good afternoon, Your Honor. Attorney Lisa Lozano Short, appearing on behalf of Ms. Vera Collins, who joins us by Zoom as well.
Okay, thank you. So this was set for a final hearing today. I am in receipt of a proposed consent judgment of divorce. Mr. Rickard, is that how you wanted to proceed today?
Yes, Your Honor.
And Ms. Short, is that how you wanted to proceed as well?
That is correct, Your Honor.
Okay, so I'll swear both your clients in at the same time. Mr. Collins, now, if you could please unmute, there we go. And Ms. Collins, if you could both raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Thank you both. You can lower your hands. And Mr. Rickard, if you'd like to start with your client, please, as plaintiff.
Thank you, Your Honor. Mr. Collins, did you file a complaint for divorce in this court?
Yes.
At the time you filed, had you and your wife resided in the state of Michigan for at least 6 months?
Yes.
And at that time, had you also resided in Otsego County for at least 10 days immediately prior?
Yes.
Were all the allegations in your complaint true at the time you filed?
Yes.
Are they still true today?
Yes.
As you sit here today, is there any chance of saving your marriage?
No.
Okay. We attended mediation with Gerald Soborowski. Do you remember that?
Yes, sir. Yes.
At mediation, we reached a settlement with the terms of that settlement placed into our judgment that you reviewed and signed.
Yes.
Now, knowing what you know about your situation, do you feel that the settlement reached was fair and equitable?
Yes.
You understand that both you and your wife are waiving your rights to receive spousal support from one another, correct?
Yes.
You understand that that right is forever barred, released, and waived and cannot be changed for any change in circumstances. Understand that?
Yes, sir.
You understand that you had a right to go to trial.
Yes.
At trial, you could have done better or worse or exactly the same as you did here. You understand that?
Yes.
Knowing that, do you still wish to waive your right to trial and ask the court to enter this judgment?
Ask the court.
You wish to waive your right to trial, Clarence?
Yes.
Yes. Sorry. I agree.
And you wish to have the judgment entered, correct?
Yes.
Okay.
Sorry.
I have nothing further of my client, Your Honor.
Thank you. Ms. Short, did you have any questions for Mr. Collins?
Mr. Collins, did you file for divorce of your own free will?
Yes.
Did you sign the settlement agreement of your own free will?
Yes.
And then did you also sign the final judgment of divorce of your own free will?
Yes.
Thank you. Nothing further, Your Honor.
Okay, and Ms. Short, did you want to take any testimony from your client?
Yes, thank you, Your Honor. Ms. Collins, You are aware that your husband filed for divorce, correct?
Yes.
And you participated in mediation of the divorce settlement, correct?
Yes.
And during mediation, we came to a settlement agreement that you not only testified on the record that you were in agreement with, but also signed the settlement agreement, correct?
Yes.
And per that agreement, we know that there are some debts that's going to be paid out of a particular account, correct?
Yes.
And you and I have had a discussion today where we are going to dispute one of those payments, but it's provided in the judgment that if there is a dispute, we just need to show proof of it and there's a resolution of that debt, correct?
Yes.
Okay. And we reviewed that judgment of divorce. You do understand that the court could have set a trial in your matter where you could have received more or less or the same that you've agreed to sign in the settlement for the judgment of divorce, correct?
Correct.
Okay. Are you currently pregnant, Ms. Collins?
No.
I have nothing further, Your Honor.
Thank you. Mr. Rickard, did you have any questions for Ms. Collins?
No, Your Honor, thank you.
Oh,
All
Your
right, the
Honor,
court-
Your Honor, I'm
Yes.
sorry. I did have one further question or to Verdeel, my client, for clarification. Ms. Collins, you do know that per the settlement, your husband is going to be paying $3,000 towards your attorney fees with Goldman and Associates. You're aware of that?
I was hoping that he paid all of it.
Right, but the agreement is that he's going to be paying $3,000 towards it.
Okay. Yeah.
You're correct? You understand that?
Mhm. Yes.
And you understand then you will be responsible for any remaining attorney fees owed to the firm, correct?
Yes.
Ms. Collins, are you satisfied with my representation today?
Yes, I am.
I have nothing further, Your Honor.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce. I've signed the judgment. And that's all I have for this hearing today. Thank you. All parties are free to disconnect. The divorce in this case is now final.
Thank you, Your
Your
Honor.
Honor.
Thank you.
Yeah. You're a liar. You shouldn't have lied. He heard me. He heard me. I was making sure he heard me.
Okay, looks like we have everybody connected. So we'll go on the record now. This is Johnson versus Trillium Companies Incorporated. This is file number 2419593. If I could have both counsel put your appearances on, please.
Good afternoon, Your Honor. Mark Connolly on behalf of the plaintiff, Ms. Johnson.
Good afternoon, Your Honor. Mark Mueller on behalf of the defendants.
All right, thank you. Mr. Mueller, this is your motion for summary disposition today. I did have an opportunity to review your motion and brief along with the exhibits that were attached, including the depositions of Ms. Johnson, Dr. Isinyenko, I'm not sure how to pronounce that. So I had a chance to review all of those. Mr. Connolly, I did get your response brief. I had a chance to review that as well as the documents that you attached to that in support of your response and request for denial of the motion. So today is the date and time for oral argument. Mr. Mueller, anything that you wanted to present today by way of argument?
Your Honor, we actually resolved this case on Friday.
Oh,
and
I guess I said all of that. I didn't need to say all that.
Yeah, I was
Okay.
going to interrupt you, but I didn't want to, Your Honor.
Once I get started, sometimes I just keep going.
Yeah.
So, all right.
So anyways, we agreed that we would just put it on the record, though. The matter has settled in the amount of $40,000 in exchange for a dismissal with prejudice, along with the plaintiff, Ms. Johnson, to sign a release. And it would include her being responsible for any and all liens that may or may not be existing.
Okay, thank you. Mr. Connolly?
That is a correct rendition of the agreement that we reached last week, Your Honor. And we'd ask the court to take that on the record today. Ms. Johnson can answer any questions that the court has of her.
I don't have any questions. Can you give me an idea of how long it'll take for closing documents to be submitted to the court to sign a dismissal?
I would say within the next, at most 30 days. I have asked my assistant to expedite any year-end settlements because both the plaintiff's bar as well as the insurance carriers like to get cases settled at the end of the year. So I think 30 days would be ample.
Okay. All right. So I'll just look for that. That's all I have, other than to thank counsel for working towards a resolution. One of my last comments to both of you following the hearing today in my notes was to say that this is a case I think that really needs to settle. So I'm glad that it did. I appreciate both your work on that, and all parties are free to disconnect. Thank you.
Thank you, Judge. Thank you, Mark.
Thank you, Your Honor. Thanks, Mark. We'll talk.
Thanks.
Okay, just waiting for Mr. Shimovitz to connect here. Okay, Mr. Shimovitz, if you can unmute, please, and we'll go on the record. And this is Kent Family Farm versus Benjamin Vaughn et al. This is file number 2419708. And if we can have counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Paul Slough on behalf of Kent Family Farm, and Mr. Josh Kent is seated beside me.
Jeffrey Shimovitz on behalf of Ben Vaughn, the defendant in a counterclaim, plaintiff.
Good afternoon, Drew Norton on behalf of defendants Rosemary Curatello Trust and Michael Yunus.
Good afternoon, Your Honor. Melissa Pronzales on behalf of defendant Mers.
Good afternoon, Judge Richard Smith on behalf of Century 21 and McGuire.
Okay, thank you. So we're on the record today for a hearing on, I believe it's just defendant Vaughn's motion for a preliminary injunction. That's all that I saw in terms of the filings. Have any of the other defendants or parties joined in that?
No.
No. Okay.
No, Judge, in terms of Curatello and Yunus, we're here to observe. We haven't taken a position on this, but interested in the outcome.
Okay, certainly. Did any of the other parties besides Mr. Shimovitz and Mr. Slough, any of the other counsel want to be heard on this issue since you're not involved? And just raise your hand if you do. No. Okay. Okay. All right. Great. So that helps me kind of narrow things down in terms of what we need to address for the record today. So Mr. Shimovitz, I did get your motion for the preliminary injunction. I had a chance to review that. Mr. Slough, I got your response and had a chance to review that. So Mr. Shimovitz, this is your opportunity for oral argument. Anything you wanted to present to the court today by way of argument?
Basically, we will stand on our motion, but I would add as minor things. In asking for a preliminary injunction, Ben Vaughn would be agreeable that the preliminary injunction would go both ways. It would bar him until the hearing on the merits, as well as bar Kent from using, particularly commercially using, the disputed property.
All right. Mr. Shimovitz, I mean, I'm sure Mr. Slough is going to raise this in oral argument, but he raised it in his written briefs. In terms of, the requirements for the court to issue a preliminary injunction, as you know, that's an extraordinary remedy. And there are a number of factors that the court has to consider. And Mr. Slough pointed out in his response that I don't know that any of them were addressed in your motion. In particular, any kind of allegation that there's a danger of imminent and irreparable harm. I mean, can you address that for me? What about the kind of the four factors that the court looks at? Why were none of those addressed in your motion?
This civil action was started by Kent Family Farms way back in 2024. At that time, Kent Farms invoked the equitable and jurisdictional status of this court. The threatened, and as of September 4th, they threatened expansion of their activities on the disputed property were a new post-filing occurrence. In addition to filing an answer to their complaint, which had as count one, quiet possession, we entered a counterclaim seeking competing count for quiet possession. We have two parties that are disputing who is entitled to possession and title to the disputed property. The injunction that was initially entered was by stipulation, and it involved both parties. Mr. Slau's client, my client. My client has obeyed that preliminary injunction. We contend that Mr. Slau's client, Kent Farms, is violating. It will violate, or at this time may be presently violating, if not the letter of the law, of the injunction, certainly the spirit. In terms of money damages for this particular aspect, we have sort of minor damages for that. We think the major money damages was already occurred by the time that Kent family filed the initial complaint. In terms of equitable grounds, this is the disputed property is part of Mr. Vaughn's residence. The invasion of his property, his real estate, would constitute by itself an action, but coming on top of the status quo as set by this court's order, initial preliminary injunction, and the sort of the status of the civil action. What we have with these two competing claims to ownership and possession is a fact question. Both parties deny the other party's claims, and because Kent family filed a demand for trial by jury in its complaint, a jury question, the factual discrimination is now up to the jury. That's by Kent's invocation.
All right, well, what you're asking for in your motion, Mr. Shumovitz, is an injunction against the Kent family farm from occupying or commercially using the disputed property. And so you're not alleging in your motion that they violated the stipulated injunctive order that was issued back in 2024. You're asking for a new injunction. And so what I'm asking is, one of the main requirements for injunctive relief is a showing of a particularized showing, not just general allegations of imminent and irreparable harm. And so there wasn't anything in your motion outlining that. And that's, to me, one of the key factors that the court would have to find exists in order for me to grant your motion. So I'm just wondering if you can articulate for me what is the particularized, specific, imminent and irreparable harm that's going to occur to your client here if I don't grant your motion for the injunction.
Your Honor, I don't believe that I can give you irreparable harm. To the extent there's money damages, they can probably be dealt with a jury verdict.
All right, okay. Well, I mean, based on your statements, I don't know that the court can grant your motion for an injunction. Mr. Slough, I mean, at the risk of snatching defeat out of the jaws of victory, I mean, is there anything that you want to state for the record here?
Well, I briefed it pretty thoroughly, Judge. I don't need to go back over all of that ground. I think as the court's pointed out, the motion must be denied for the reason that was pointed out. But I have to ask for costs. You know, my client had to pay me to brief this issue, to appear today at the hearing, and there was simply no merit to the motion under the circumstances. I mean, you know, there is no irreparable harm that's been identified. The brief flat out states the damages are monetary damages, and the law is crystal clear. If there is, you know, legal relief available, they are not eligible for equitable relief. So I don't often do this, you know, ask for costs, you know, or assert that a motion doesn't have legal merit. But there was no legal merit to this motion, and it needlessly increased the cost of litigation for my client. So I have to ask for costs. Thank you.
In response to that, the invasion of a person's homestead, his property, I believe is per se invokes equitable relief. That's really what the quiet title that we're alleging, as well as Ken is alleging, comes down to. I've tried to respond with candor to your question about irreparable harm, but every day that Kent uses the disputed property before this court has had a chance to determine who's entitled to use in title is a violation of those rights. And I would say that just in defense of the action for costs.
All right. Well, you know, again,
Judge, can I respond?
Sure.
I mean, I just want to point out, I mean, I cited in our response the deposition testimony of Mr. Vaughn, and I flat out asked him that question in the deposition. You know, how is it that you not having access to this property is preventing you from being able to use your property or enjoy your property in some way? And he could not give me a clear answer. And you can read the deposition testimony, it's attached to my response, but he could not give me a definite, clear answer of how he was being harmed by the fact that he didn't have access to these 2 and a fractional acres because of this lawsuit. That's all I wanted to say. Thank you.
Okay. All right. Again, I had a chance to review the written submissions of the parties. I've listened to each side's argument here today. Mr. Shimovitz, I certainly appreciate your candor and in answering my questions. And the motion was for a preliminary injunction. It cites the court rules pertaining to preliminary injunctions. Injunctions are an extraordinary remedy. A preliminary injunction can only be granted by the court after it considers a number of different factors. Those are not, you know, an itemized list or a checklist that the court has to follow, but they are factors that the court must consider in determining whether or not injunctive relief is appropriate. As I've indicated, and I think most courts recognize, one of the most important factors in granting injunctive relief is the existence of a particularized showing, either by affidavit or otherwise, of irreparable and imminent harm that can't be remedied by money damages if a preliminary injunction is not issued. And again, Mr. Shimovitz, I certainly appreciate your candor. It's consistent with what was in the brief, and in the court finds there has been a lack of a showing of that imminent and irreparable harm that can't be remedied by money damages. And so whether or not Mr. Vaughn is ultimately able to prevail, and whether or not he's ultimately able to show grounds for entry of some type of injunctive relief later on, there certainly has not been an adequate showing on the record here today that would justify issuance of a preliminary injunction. And, you know, given the lack of, I think, addressing the factors that the court must look at, and acknowledgement that the most important factor, in my view, is not present. I think this has resulted in undue costs and attorney fees to Mr. Slough's client having to defend this. And I don't normally do this, and I certainly don't think it was intentional on Mr. Shimovitz's part, but certainly this was not a well-grounded or legally justified motion at this time and as it's been presented. So Mr. Slough, number one, the court will deny the motion for preliminary injunction for the reasons I stated. Number two, Mr. Slough, the court will award costs and reasonable fees for your preparation of the response and your appearance here today. And I'll ask that you submit your bill to the court. I will review it for reasonableness and then issue an order reflecting that.
Thank you, Judge.
All right, that's all I had for today. All parties are free to disconnect at this time. Thank you.